you mind bringing out Miss Gibbs? Yes.
Council for recess?
Joseph, who you got?
Judge, I've got Benny Hernandez.
How you feeling?
Yeah, I'm not too great, but I'm managing. Judge, we can, this case, we could possibly do a plea on it today if we can do it all through the portal, if I can sign the documents through the
Yeah,
portal.
I'm sure we can.
Okay.
Do you know what offer you're going to take?
The state's offered 15 months of probation.
Okay. Yeah,
This
you
is
mind
second
writing it
second
Yeah,
DWI.
everything can be done through the portal. Do you have your guy's phone number so you can, talk to him
Yes.
outside?
Yes, I do. I believe he's in the courtroom right now.
Benny Hernandez, your lawyer's going to call you now. Step outside, talk to him about everything, and then when you come back in, we'll get it done. Please. Okay, Joseph, we'll get it written up and put in the portal for you.
Right here is where the judge starts weighing risk. Visry's responsibility. A lawyer asks for a PR bond, the court has to pause and ask, can this person really be trusted to come back? And with multiple cases already stacking up, the tension is building. What do you think? Should past charges influence bond decisions?
Thank you. All right.
Sure thing. Okay, so Ms. Gibbs, the reason I'm bringing you out now is that your lawyer is asking for me to give you a PR bond on your failure to identify oneself. I don't know, I have to look at what's going on in your life to see, should we give you a PR bond? Are you a danger to the community? I mean,
Not at all, sir. Not at all. I'm a college graduate. I've got 4 kids I need to take care of. I have a job. I have a vehicle. I have no problem getting to court at all. Like the last 2 court dates that I had with my felony, I had a miscarriage and I was in the hospital, and they're aware of that.
everybody tells me it's little bunnies jumping in the woods.
That's the only thing it was. I had a for real miscarriage.
I get it, but you're on bond for a felony endangering a child.
Mhm.
You've picked up 2 fraudulent uses. And now, after those 3 cases, you've now picked up a 4th case of failure to identify oneself. So
They were all in this.
stop.
Okay.
You have the right to remain silent. I just want to know what's going on
Yes, sir.
to see whether we should give you a PR bond, because this is not a revolving door,
I understand that.
Yeah.
I apologize.
So we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay, please.
Thank you. On April 2nd, 2025, the officer was monitoring a neighborhood police radio broadcast. The officer heard a broadcast call for the theft of a department store off of East Sam Houston Parkway in Harris County, Texas. The caller gave a description of the defendant and explained the defendant had just left the store. The officer arrived in the area and found the defendant as she was described by the caller, along with a male individual with the defendant. The officer observed the defendant and the individual enter into a motor vehicle and exit the parking lot. The officer observed the motor vehicle have no front license plate and expired registration. The officer conducted a traffic stop and made contact with the defendant. And the defendant identified themselves as Kathleen O'Brien, date of birth, May 24th, 1982. The defendant stated she did not have any ID card on her person. The officer looked up the defendant by the name and date of birth on the public safety photo, and they did not resemble the defendant. The officer asked for the name and date of birth of the defendant once again, and the defendant gave the same name and date of birth. Due to the photograph not matching, the officer attempted to confirm the defendant's name and date of birth with the mobile FIS. That would turn the actual identity of the defendant as Candace Lynn Gibbs, date of birth July 16, 1981. Along with a Harris County Sheriff's Office mugshot of the defendant that matched the driver of the vehicle.
So they didn't charge you with a theft?
I don't believe so, Your Honor. Or they did not.
So what's going on with the 2 fraud cases that she has that shows like no bond?
Not sure.
You know anything about those cases, Lori?
No, sir. I know that she went to court on the 15th, 14th,
15th. Yes,
on
ma'am.
the 15th on the. I received an email from her felony attorney stating that this was the only case that was holding her in, and to see if I could move her up to get her out.
She said something that they weren't filed, or they weren't, something hadn't been done where.
Yeah, the she said they weren't filed yet.
They're filed. I guess the judge just hasn't signed it yet.
Your Honor, it looks like there was a plea offer made originally for the endangerment of a child. And that plea offer has been made now on the fraudulent use case. That was just, I believe, discussed between the felony prosecutor and the defense attorney.
In this case, Lori, in the fraudulent use case, in her clutch, as they pull them over, she has the identifying credit cards, debit cards of 1, 2, 3, 4, 5, 6, 7, 8, 9.
That's a lot of stolen information when a judge hears numbers like this. 25 pieces of identifying data. The whole tone of the case shifts. Thyson's T. A simple mistake anymore. This is a pattern. Viewers, would you still grant another PR bond after hearing this?
9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25 different items of other people's identifying information. You are on bond for endangering a child. You pick up 2 fraudulent use cases and now allegedly at a store doing whatever with a failure to ID. I'm not going to sit here and give you yet another PR bond. You know, at some point we have to say when, and now is that time. Your bond, literally $50 to get you out, right? But I can't sit here and continue to just perpetuate this thing over and over and over. All I want is my community to be safe, you know?
I understand that,
So
sir.
I'm going to find probable
In an
cause.
abusive relationship.
Don't say anything, but got to understand that, right, I'm not going to give her a PR bond, Lori. I'm sorry. All right. So, ma'am, what we'll do now, your felony cases are set for the 30th of April. We can set you for the day after and we'll go from there. Okay. Thank you, ma'am.
That's what we said.
Okay, so Mr. Sherrill, you're charged with terroristic threat. You're facing up to a year in jail and or a $4,000 fine. We have already done probable cause. I found probable cause to go forward with your case. We set a bond. He's made the bond or no?
Yes, he has.
You've made the bond.
Yes.
Okay. So I am entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Taylor as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand? They're not currently together now?
No.
Okay, great. So there's just no,
So,
I don't want to talk about the case.
no, it's not. She still like communicates with like my family and my friends. Like I don't even live here, and it's events coming like my best friend's wedding. I'm going to the wedding, but she's trying to come. So how do I have
Got to be careful, you know? You're not to have any contact with her, you know?
Sounds like she's using, I don't know if she knows there's a restraining or a protection
She
order.
is using, the officer was a personal friend, so that's why.
Okay, well,
So this merely says that you can't go to or near her residence, right? Where she lives, where she works. Don't have any contact with her. The problem is that there's a lot of vindictive people in this life. You know, if you go to the same place that she is and you end up bumping into each other and she says something to you, you know, it's a recipe for disaster. So you have to be very careful. If you go to this wedding and she's there, it's like a ticking time bomb. So you need to be just very careful because I don't know, you know, what kind of person she is. If she's that type of person, you got to be very careful because there are a lot of people that will call them and say, hey, this happened, when it's just not true. And if it does, they issue the warrant and then it's up to you now. You pick up another charge. So just be careful, you know? All I want is just you not to have any contact with her. Don't be in possession of weapons. As long as you can do that, we're cool. I'm going to waive your appearance so you don't have to waste your time coming to court here as well. Just stay in touch with counsel and he'll tell you if and when you have to come back to court here. So you don't have to come back and forth every single court date. Just stay in contact and he'll let you know if and when you have to come back.
I appreciate it.
You have any questions?
I guess so.
You live in Baltimore, right. Okay. So for now, what I'm gonna have to do is I'll have you sign a reset with Victoria. We'll have you take a seat in the juror box. We'll get your bond conditions, have you sign it, and after that, you're free to go. Okay? Hi, Anna.
Good morning, Judge. Hi, Bruce.
Yeah.
I've got a couple to talk to you about this morning.
You do the easy ones first?
Well, whenever I have to talk to you, Judge, they're never easy.
That's not true.
Fair enough, fair. But these,
I know. Okay.
the first one is going to be Wilson Keonje. Start with the less difficult.
Okay.
Can we hear PC on this one?
Is it, you say Keontae? Keonjae?
Keon.
Okay, yeah, of course.
On February 6, 2025, a law enforcement officer was dispatched to an assault at Provision High School. Law enforcement officer arrived and observed 15 to 20 students fighting each other and struggling with staff members and security guards. The law enforcement officer retained a number of students. After the scene mostly calmed down, the female was struggling and fighting against male students to run out onto the floor and rejoin the fight. The law enforcement officer approached the males and told the female students' hands behind her back. The law enforcement officer got closer to the defendant, turned towards the law enforcement officer, put his arms up to stop the law enforcement officer's progress towards the female and said, "No, no, no." The law enforcement officer grabbed the defendant's shirt and told him not to interfere, he would be taken to jail. The defendant replied, "I will," and remained in the law enforcement officer's path. The law enforcement officer handcuffed the defendant and ordered him to get on the ground and began pushing the defendant towards the ground and told him to get on the ground again. The defendant remained on his knees, pushing out against being pushed. The law enforcement officer pushed the defendant down towards the wall. The defendant pushed up, causing the law enforcement officer to fall to the ground. The defendant righted herself before continuing to struggle with the defendant to get him to the ground. I believe that's a typo. The law enforcement officer righted themselves.
So there's a fight.
Yes, Your Honor.
The officer is asking him to move, get out of the way, so he can do whatever he needs to get done, and he just refuses to get out of the way.
Yes, Your Honor.
Anna?
So it sounds like the interference is my client doing this.
He's impeding the path of where he's trying to go or what he's trying to do,
Okay.
right? I mean,
That's what I have, Your Honor.
is there a body cam on this?
It looks like we do have a significant amount of video.
You seen the body cam? Does it show that?
I have not watched them all because it's quite a bit, Judge.
Okay.
But
You remember, it's a low burden,
I understand.
double cause, and he's, the officer says, "Hey, move, man, I gotta get this stuff done." And he's like, "No, I'm not gonna move. I'm gonna stay here, just, I mean, I get it's just standing there, but,
Okay.
so look at the video. If you see something different, let me know."
Okay. The next one I have to talk to you about is Torrance.
Come up, Ms. Torrance.
I've spoken with the state. And so there's kind of a couple of things going on. I'm assuming you want to do the BVR first. I've spoken with the state. We are going to ask for a hearing. I'll let the state speak for themselves because
Your Honor, we do not have any toxicology back. We have blood alcohol report, but that is not the toxicology report.
Well, talking about the bond violation
Bond
report.
violation, I apologize.
It's okay.
I apologize.
I don't think the state is prepared to have the hearing today. But
I've got bond violations. The SCRAM device has confirmed alcohol consumption violations on 3/15/25 at 1:51 PM, 3/23 at 7:14. Confirmation was received 3/25/25 by the analyst, and it's a third bond violation.
I understand, Judge, but
Let her go.
the rules of evidence apply at a bond hearing, and we need somebody with personal knowledge or somehow to get around that hearsay to do the hearing, and I don't think the state's prepared to do that today.
We do not have anyone here to do that today, Your Honor. I apologize.
Hey, who do we need? What SCRAM analyst do we need to get down here? So we can, right, so they can testify that what's in the BVR. I'm sending her now for a drug and alcohol test right now as well.
This is where things get messy. The SCRAM device flags 3 alcohol violations, but the statenist prepared to prove them today. In court, solid evidence can fall apart without the right witness. Ever seen a case stall simply because no one showed up to testify?
I'm going to send her for the test now.
Right now.
Okay. Okay. Have a seat, and then once they put the order in, we'll have you go over there. Okay.
She can have over recorded during.
Okay. Okay. Go over to 41 Sanderson. Okay.
And then Anthony, do you see, who do we have that can come?
Yeah, I'm
You
gonna get
mind?
the name and.
Yeah, okay.
We'll
get it. I'm gonna try to get it today. Okay, who else?
And then, well, so the secondary issue, on Ms. Torrance is we have gotten the alcohol report back. They sent the, blood off to get analyzed for toxicology.
Oh, Lord, did you just send the blood off?
And Judge, if,
No,
Verify when that.
this case is 233 days old and we have violation after violation. I'm not waiting anymore. She's way too much drama for me and I'm ready to set this thing for trial. I'm not doing it anymore.
For the courts, I did email the person on that side, just got a response. Toxicology analysis still in process, pending completion, it's likely requires some time for the lab board received.
Did you just send it?
No. We've been sending follow-ups. This was like a last Hail Mary attempt of, do we have it or do we not? They still have it.
Do you have other things to go on regardless?
I think we
You
have.
know?
Spoke with defense counsel, there is, I mean, proper, there was alcohol in the system.
Well, look, it doesn't matter to me, however you guys want to do it, but to me, way too much drama. I'm setting this case for trial. That's it, you know, because
yeah, and he has laid an offer.
I need to talk to her about the offer. If it's not moving anywhere,
Okay.
I'm setting it today.
Okay,
Way
and
too much drama.
just to remind the court, when I was here last time, you gave them 30 days and said if they didn't have the report, that it wasn't coming.
Okay,
I understand the state has to do its job.
so can you take a look and then, you know, take a look and then let's go. But yeah, I'm ready. Hi, Maverick. How are you, man?
Good, good, you?
Sorry to bring you down here.
No, it's good.
Is your client here?
He is. Should we bring him
Come
up?
up.
I did speak to pretrial and they did confirm that they are kind of in the mistake. We didn't not comply. This is because we did come here to court on a Monday, 4/7. And when you were here, you already knew his results.
Last meeting.
Oh, Bennett.
Okay.
And so you already knew his results and you told him, look, I already know your results. There's no use to test him on Thursday. Because he was on a Monday, Thursday at the time. Let's switch him to once a week. We can't tell him when he would be tested next week, but you know, which day, but sometime next week he'll be tested. So on Thursday, they of course call him and he's like, okay, I already was told not to do it. And then he did not go. And so it put him in the system as a BVR. When he was, in his opinion, following directions.
Okay, I'm gonna send him now, I
That's
guess.
fine. And they even said.
As long as you're
today.
clean, I'm happy. I just don't want anything in your system, especially oxy. You know, that's all I want. I'm not asking for much, you know? We'll send him for a test now. Hopefully he's clean. If so, everybody's happy. I won't ding him on this. You know, if he's dirty, I don't know what we're gonna do. So let's do this, because it's gonna take a while and I know how busy you are. Leave me your cell phone.
I'm trying court 3 all day today.
But I can text you, so that way you don't, you know, don't say it.
Okay.
I'm here. If you write down your cell phone, please, and then I'll text you. All right, just take a seat for me. We're gonna send you here momentarily, Mr. Ben. Hi. Hi,
Lacey Johnson, Mental Health Division Judge. How are you?
great to see you. What's new?
You know, just trying to do some more work in misdemeanor. And if you haven't heard, we are supposed to be having full-time misdemeanor mental health prosecutors coming online in the next couple months. So we're very excited about that.
That's exciting.
But in the
Well-
meantime, we're trying to,
Guys that you have now are great. They're just so understanding and great.
yeah, well, I think there's a lot of things we can do to help in misdemeanor court. And so that's what I'm here to hopefully do today. On Mr. I beg your pardon if I'm butchering his name, El Majzoub.
Yeah,
Okay,
that's correct.
he is on docket today. I can give you a case number if you
Is he
need
in
it.
in
Yes,
custody?
he's in custody.
Are you handling just mental health? No.
Yes, I'm handling just mental health.
Is that recent?
Lori and I are just handling mental health.
But is that recent or no?
No, since I've been here, I've just been in with mental health.
Okay, what was the cause number?
So his first cause number is 2556958.
And that's the document that I filed. It was the agreed stipulation of evidence. That's what we filed.
And so I got a notice that she had filed for a motion for competency exam. I took a look at the cases. This gentleman has been through competency restoration services before and has a well-documented mental health history. And so I told her, rather than waiting for an exam, which I feel fairly confident I know the outcome of, I will agree to stipulate that he is incompetent so that we can go ahead and get the services started. So what we're asking you to do today is to sign the stipulation of evidence, sign your regular order that you would for competency restoration services.
Yeah.
And then if you could also enter the order for clinical assessment for outpatient or jail-based competency restoration. So if we can see if either of those options would be appropriate for him.
Huh?
Yes.
Yeah,
Thank you,
great.
Judge.
Yeah, just, do you mind putting it in the queue? It's on Elma Zook. Page 32? Yeah, 31 and 32. Yeah. So everything's been already filed, right? So he just put it in the queue?
So the two orders are ones that should be in your order database, but I'm happy to confirm that those are the right ones once they've been pulled up for you.
No, I don't,
It's
We
usually,
can take a,
yeah.
I don't usually file it.
No, it's usually should come from the clerks have it in their database.
yeah, that's one of the documents
Okay.
that
The other
needs to be signed.
So the order for competency restoration, and I can give you the statute if you need it. And then I can show you the other one, but it's called Order for Clinical Assessment for Outpatient or Jail-Based Competency Restoration.
That one. We'll get it. We'll get it, but it might take a
And I can show it.
Let's show them.
Okay, as soon as I get it, we'll sign it.
Wonderful. Thank you, Judge. And then
Do me a favor though, do you mind maybe like email all three? Hi, come on. Yes, please. Hi, good morning.
I'm here on Javier Marin this morning,
Okay.
and I spoke with the chief. There was a mistake about it being a DWI second. In fact, the DWI first that they thought was the issue was actually reduced to a reckless driving charge. And so this is actually just a true DWI first. And the chief has made a time served offer today that. I
Wait
believe
a
my-
second. Can you run his NCSC, please? Because usually it's a DWI and they might reduce it to an obstruction or a reckless, but it's a DWI. Right? And the thing is that the last thing I want is for him to wrap his car around a pole because he continues to get proverbial slaps on the wrist, you know?
And then at this point, that's all you need to. If, so when you send these stuff together for the outpatient or jail-based programs, they'll send us back a report and if,
Sure.
he's admitted to either of those programs.
So we did submit a PTI litigation packet for him as well, just under the assumption that.
I mean, that's up to you guys. The problem is it's 190 days old, right? That's should have like a long time ago, right?
Yes,
it's really.
Let me know if you need to come back. Otherwise, we maybe want to check in and.
They filed it as a second, and I'll tell you, let me look at the information.
Sorry, give me 1 second.
Yeah, it looks like you convicted of a DWI in Lawton, Comanche County, Oklahoma in '01.
Laura,
Yes, Your Honor, it was. It was a DUI. Okay. Sorry, I'm trying to decide.
Take your time, there's no rush.
And like I said, it looks like the DUI was dismissed. That's.
It was reduced and wasn't dismissed.
It says dismissed, I think, there's no language on the NCIC.
So it said dismiss and then at the same time,
that
a reckless?
Says, dismisses the one, guilty, and then a guilty plea for a traffic offense. Then for the municipal prosecutor, Walsh. And then in June, so in. I'm not sure, it might have just been this. Was it, where do you have that?
It's from the attorney of record. He said that he was speaking with Abigail Balance. From my understanding, the previous introduced a reckless driving equivalent from Oklahoma, and then she wrote back.
I'm sorry, the NCIC just isn't clear exactly how that transaction.
Yeah, it's not an invest second, it truly is not, it was, we got to.
Reduced from a, it was,
I don't know what happened in Oklahoma. But it is not that DWI. That is.
was it a DUI that got reduced or reckless or an obstruction?
Alright, there you go. You're pretty good.
Oh, Jane, that's higher. So I misspoke, Your Honor. We did not get a JNS back because there is no JNS from Oklahoma. The only thing I can see was there was a DUI charge, no information on it. It's hard for me to track, but there are no DWI convictions. So it's hard for me to track to see if that charge that we have that was, we don't need the JNS on, was the one that was.
They usually don't file it, just.
Right, because it was a class C. Or well, it's a mall, so it's different. But it would be the equivalent of class C here.
What do you want? One time serve?
We would like to give that offer to our client today because
I mean, we got to do something today. It's 190 days old.
it's today, but
Oh, it's waived.
we'd have it coming on the next setting.
Yeah, so what we'll do is we'll set you off a week. Okay, have your client come in so we can take care of it. You know, I'm okay with just, can you go ahead and do the reduction now? How do we?
So, yes, Your Honor. So what I can do is I could, because we're reducing it, basically I can complete paperwork, Your Honor. We are claiming,
Well, we'll need the new NCIC regardless, right?
I'm sorry.
We'll need the new NCIC regardless.
Oh, yeah.
Do you know the NCIC by heart? on the
In our
first?
offer, the offer we've made, it's within the consent.
Okay. Is it above a 0.15 or no? Okay, yeah, if you want it, I'm okay with it.
Judge, and also we did apply for PTI. I don't know if that's still on the table.
Do you know, have you turned in? Have you turned it in?
And as of yesterday, yes.
Oh, as of yesterday.
As of yesterday, Judge.
Do you see that it's been turned in?
So we submitted it to,
So regardless, I mean, do you want the PTI? Is that what you want?
my client would really like that. He would.
So let's, I mean, go that avenue and we'll see if they are, down. You're probably, have you filed mitigation paperwork explaining to them that it's not a second though?
Yes, Judge.
Okay, great. Because they need to know, because they're going to automatically refuse you if they think it's a second.
That was my whole look before I made this. But once I saw it, and I can tell you, Your Honor, the convictions were passing on.
Okay. I just want to confirm that you have the image.
I don't know that.
It was sent to Lindsay Tizard.
Oh, no. That's, okay.
And Flo Dufocon.
So let me.
You guys get together. I'll give you a week to 2 weeks to get the response and we'll go from there. Yeah.
Thank you, Judge. I appreciate it.
2 weeks. They're filing the PTI today.
Okay.
Mr. Hernandez, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 1 year in jail. This is to be probated for 15 months. As part of this agreement, you will do a DWI repeat offender education class. You will do 2 victim impact panels. You will do a TRAS. This is an evaluation to see what other conditions you need. If they assess other conditions, you must fulfill them, including substance abuse treatment. No drugs, alcohol, no breath test refusal. If you are pulled over while on this probation and an officer asks you to submit a breath test, you must do it while you're on this probation. 40 hours of community service. Do you have any children, sir? Do you have any children? $100 one-time donation to the Houston Food Bank. Three days in Harris County Jail as a condition to begin May 9th. You are way, way too young to have 2 DWIs going on your record now. This is a damn shame. And the reason is because you will probably be driving for the next 50 years. The problem is that are you going to remember this in 20 years? Are you going to remember this in 30 years? Look at me. What happens if you pick up another DWI? No. No. Prison. You're looking at 2 to 10 in the penitentiary if you ever pick up another DWI. And you don't have to be sloppy, falling down drunk for you to get another one. Just the mere smell in and of itself. When they look at you and they look at your record, they're going to make assumptions. If it walks like a duck, talks like a duck, somehow I have to get a hold of your attention so that you understand that we mean business, that it's unacceptable for this to continue to happen. I'm now going to hit you with a surcharge of $4,500 that you will be required to pay. And if you don't pay it, every $100 that you owe, you will sit 1 day in jail. Do you understand? We will give you a sufficient amount of time to pay, but if you start clowning, you pick up another case, you consume alcohol. If you pick up another DWI, I will issue a warrant for your arrest. We will have a hearing, and you're looking at an entire year in jail. Do you understand?
Yes, sir.
I hope that you don't pick up a felony, but the problem is that time heals wounds. In 30 years, you will have forgotten about this, but the law never forgets. So you go out on a date, you win the lottery, whatever. You understand?
Sir.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you accept this agreement, you are stuck with this until you're done, you complete it, or if it gets revoked. You understand?
Yes, sir.
Is this what you want to do?
Yes, sir.
How do you plead to the offense? Guilty or not guilty?
Guilty.
I'm going to find you guilty. So the total fine that he will owe is the $4,500, and how much a court costs?
The 4,500 plus the 410. So
So-
4,900.
You will owe now $4,910. We will give you at least 2 years to pay. If you need more time to pay, we can give it to you. If you have any problems while you're on this probation, you can come back and talk to us. She's an extraordinary person, always willing to help. It's not about, the worst possible thing you can do is just take off. Issues come back, we can always work through anything. I am now required to suspend your license. I'm going to suspend it for 1 year. Do not drive. You understand? You get popped driving, it's not going to go well for you. You understand? Okay, man. Good luck.
Your Honor, one additional,
Yes.
I'm sorry, Judge. One additional thing.
Talk to me.
Mr. Hernandez has had a breathalyzer in his vehicle for the past 7 months. He's been in compliance the whole time. Does he have to keep that in the vehicle?
So I'm suspending his license, Joseph. I'm
Okay.
suspending it for a year. So what we'll do is we'll take it off now, once he gets his portable device. He's got to get the portable device first,
All right.
okay? You need to understand that every officer in this state knows that you're not allowed to drive unless you have an ignition interlock in your car. You get pulled over and you don't have an interlock in your car, they will arrest you and put you in jail. And then we file a motion to revoke. So don't attempt to drive. Find another way around. Do you understand? I know it's a hardship, but somehow, Mr. Hernandez, we got to get a hold of your attention. Look at the news. Every day someone dies in our county. Hopefully this is the last of it. Good luck. Waive all his fees as far as supervision. Yeah. Okay. All right. Good luck, Mr. Hernandez. Hi.
Thank you, Judge.
Thanks, Joseph.
You're welcome.
Take care, man.
You too.
Okay. Hi.
But, well, this one's Butler.
So what'd you find?
Yes, I spoke to his sister, Dorisha, and she confirmed that she can pick him up once he's released and that he can stay with her for as long as he needs. And keep an eye on him to make sure he stays out of trouble.
Yeah, I'm putting a monitor on him so we know where he is. Okay. Do you mind bringing Mr. Butler out? Yes.
I did request if she can come this morning, but she had to take her kids to school. So she.
So, but it takes time to get out anyways. So it takes, can we do release instructions to a particular person?
Can I do?
How do we do that?
So if they're in jail and we're trying to release them to a certain facility or person,
No, to a person.
we can do that.
We can do, say it again.
Either the state or defense will have to file.
So there's a motion that you can file that he gets released to that person.
Okay.
I don't know how we get it though. I don't know.
I
how
have
we
a
get it.
copy of one.
So that way we can put her
But it
name
was
on
for
it.
a facility, so I need to check.
That's okay. I mean, we can somehow,
We accept those formats, just you'll have to edit it to address the certain.
put her name on it so we know. Because I'm not gonna hope that they actually, but this way we know that he's actually released to this person. And we got to monitor so we know where he is.
Oh my God.
Copy of release instructions too.
Yes, please.
Yeah.
That would be great.
You are so very lucky that she's worked so diligently to find a place for you to go to. Who is it that is willing to take him in? It's sister?
The sister, Dorisha.
Your sister is willing to take you. I don't want you out on the street. This is the only chance that I'm going to give you to do what is right. Go to your sister's house, stay there, and try to find a job if you can. You have to remember, you're in her house, so you have to follow her rules. If she gets upset, if she asks you to do something, be nice, do it. Because if you make her upset, do you think she's going to want to keep you there? If she kicks you out, I'm going to keep you. I don't want you roaming the streets. Do you understand? I will have a monitor on your ankle so I know where you are at all times. And I'm also, so curfew as well, so he's not out in the middle of the night. We are filing an order so that she is the only one that can pick you up and take you back to the house. So you have a place to go to. This is the only chance that you have to do what's right, Mr. Butler. Can you get it done?
Yes, sir.
I'm not going to play games. So if you just take off and start roaming the streets and take off, I warrant issues, and I'm not going to do this again. No more PR bonds for you. Do you understand?
Yes, sir.
Are you sure?
Yes, sir.
Can you do this?
Sure.
Okay, great.
Thank
All right,
you.
Stacey.
I'll file it this morning as soon as I'm done.
Sure, thanks.
Thank you. And I'll be back for Mr. Ramos,
Let him know that his curfew of 9 p.m. to 6 a.m.
9 p.m. to 6
And
a.m.
then he's got to stay at the house. Do you think he can work?
No,
Do you think he can work?